All right, you're still watching TVC Breakfast. We now take you through this very, very important conversation. Now, a community in Rivers State is taking its environmental case against Italian oil company ENI to Italy's Supreme Court after a lower court dismissed its lawsuit over decades of flooding. The Aggah community says flooding started after oil facilities operated by Aggah, an ENI subsidiary, distributed national water channels, leaving residents affected for more than 50 years. Now, community leaders are challenging the court's decision, insisting important environmental concerns were overlooked. Joining us to discuss this is the Executive Director, Environmental Defenders Network, and Nigeria's lawyer to the climate, Barrister Chima Williams. Good morning, Barrister. How are you doing?
I'm good. Good morning, my sister.
Good morning. Good morning, my brother. Nice to have you as well. Now, let's go straight into this very important conversation. We're looking at something that has passed a lot of time. We're looking at over 50 years. This conversation has been going on. Now, I want to talk about, environmental safety. When things like this happen, how well do we make sure that the people actually get justice? I just want you to open this case for us again, for us to have proper understanding of what really happened and what is the way forward. Would they actually really get the justice that, they are claiming that they haven't gotten till now, looking at how long time has passed?
Right. Thank you very much for that. I will start by saying that when it comes to environmental destructions, time does not elapse except and until the act that creates that problem has stopped. And in this case, since the early 70s, late 60s, when these infrastructures were erected in Aggah community, the perennial flooding problem has consistently been there. This year, it will still be there. So it is not a problem that has already been resolved. It is an ongoing problem. So which means contest as to ending it is something that will continue. The Aggah people have taken different steps, including protests, sit-ins, demonstrations, petitions to then Nigerian Aggah Oil Company and also to their parent company, Eni, in Italy. And this process led to, in the early 80s, a panel being set up by the oil giant itself to review the problems that were being claimed to have been caused by their facilities. And that report, the committee came out with a report that actually established the existence of that problem as a result of the embankments created by the Nigerian Aggah Oil Company.
Okay.
Now, how to resolve that problem is lingering up till now, leading to, in 2019, the community of Aggah, under the auspices of Aggah Voice of Freedom, a community-based organization led by Pastor Nicholas Evaristis, approached us for support in using legal means. By using legal means, I mean employing of legal experts to look at these issues and see how, reprise can be brought to the community. Now, this led to a complaint because my law firm, who received the complaint from the EVF and Aggah people, connected and contacted our own colleagues, advocates for community alternatives, led by Jonathan Kaufman, to see how we can work together and bring justice to the Aggah people. This led to us trying to take a step that would have amounted to a win-win situation for all the parties. Not one party take it all. Victory for the community people, victory for the environment, victory for the oil companies. This was what led to an OECD first instance complaint mechanism that was lodged before the Italian National Contact Point in Italy. And that led to a process that ended and culminated in a terms of settlement, because parties now agreed that there were issues and there were solutions to be provided to that issue.
Okay.
And that terms of settlement, implementation of the terms of settlement is what led to the present litigation that is ongoing.
All right, that means there's some kind of direction now, concerning this case. I'm thinking 50 years continuous flooding in a small community like that, and I'm calculating the losses that the community must have suffered, and the fact that we're talking about some heavy weight in the oil and gas sector, ENI and Aggah. How come the Nigerian judiciary said Aggah has no question to answer? And how effective will it be taking the case to Italy or to an Italian court to hear?
All right, thank you very much. Point of correction, please.
Okay.
Nigerian court has never absolved, the Nigerian Aggah Oil Company, because there are two instant cases that have been concluded in Nigeria. One involving an individual victim of the flooding from Aggah community, Chief Akodene, where he brought an action at the Federal High Court in Port Harcourt against the Nigerian Aggah Oil Company, and the court ruled in his favor and found Aggah wanting and liable to the complaints that he brought before the courts. Also, a complaint was lodged before the Rivers State Ministry of Environment, who took legal steps on behalf of the community as complainants, in a criminal litigation against the Nigerian Aggah Oil Company. And the court also found Aggah Oil Company culpable for abatement issues. Now, why did this matter go to the Italian court? As I mentioned earlier, because of an OECD first instance complaint mechanism, which was handled by the Italian National Contact Point, the terms of settlement was actually entered into in Rome, in Italy. And now, if and the parent company, Eni, who was also a party to the OECD complaint mechanism, is involved, Nigerian court may not have jurisdiction for issues of enforcement to hear the matter against the Italian oil giants. Okay? So this was the reason why the case was lodged in Italy, in the home country of the Eni and her subsidiary, Nigerian Aggah Oil Company, who now divested their assets to Oando Nigeria Limited. Now, the court decision is now for Eni and Oando, who was previously Nigerian Aggah Oil Company. So the Nigerian courts have been upbeat on this matter, but enforcement of the judgments of the Nigerian courts had been the issue. And being the case, and being that there was a determination entered into in Italy against the parent and the daughter company, it meant that the Italian court had jurisdiction. Now, the determination of the ordinary court of Milan in this matter, who has resolved the issues, majority of it against our clients, the plaintiffs or claimants, is another issue. Now, it is because we believe that the lower court, which is the High Court of Milan, erred because they did not do proper evaluation of the evidence before it to arrive at the conclusion they arrived. That is why we have lodged an appeal at the Court of Appeal in Milan. It is not yet at the Supreme Court in Milan. It is still at the stage of the Court of Appeal. That's right.
Absolutely. Now, Barrister Williams, even though this Milan court acknowledged the case, as you rightly said, they ultimately ruled against the community. I would like you to illuminate my viewers, our viewers, as to the judge's reasoning for this, because this is a very, very complicated case. At the heart of this case is the allegation from these communities that oil infrastructure caused recurring flooding over the years. On the other hand, the court has reportedly found that the oil companies fulfilled an earlier agreement and an earlier obligation to construct drainage channels in the communities. Why do you think the claimants, the plaintiffs, the people who have suffered this alleged loss in the Aggah community are saying that these commitments of constructing drainage channels are still not adequate?
Yes, for us, our complaint to the Italian NCP was not on the non-construction of drainage or culverts. Our complaint was the flooding of Aggah community. And
Barrister Williams, I'm very sorry to cut you short. I also would like you in your response, to also tell us if there was any sort of environmental or engineering evidence provided by the Aggah community to support their claim that these oil activities are directly related to flooding.
Yes, a lot, because in my first narrative, I mentioned that the team that was set up by the oil company itself produced a report that directly confirmed the complaints of the people, and this was in the 80s, and also recommended measures to remove the flooding, and also observed that building of culverts will not solve the problem. That was in the 80s, and that had continued to be the position. And part of the actioning on the terms of settlement that was reached was a work that was supervised jointly by representatives of the oil company and the complainants, to the extent that an technical engineering survey was conducted on how this flood can be removed. And this forms part of the bone of contention of the claimants in going to appeal the judgment of the lower court, that the lower court did not take into cognizance this body of evidence that was profoundly produced before it. Okay? There is no argument as to whether the flooding of the Aggah community was exacerbated by the structures built by the oil company, which obstructed the natural flow lines of water that falls on the land of Aggah community. Now, the lower court in Milan did not rule actually that there was no problem. What the lower court said was that the terms of settlement had been fulfilled by the oil company because they have built culverts.
Absolutely.
But our complaint is that even the company's own reports made out in 1980, thereabout in the 80s, also made it very clear that culverts cannot solve the problem. So how will the court now disregard such clear evidence that was not produced by the community, but by the oil company itself?
Absolutely. But Barrister Williams.
Rather, the court also went ahead. Let me make this point, please. Went ahead because judges, when they want to be smart, they find a creative way of disarming, the claimants or the defendants in a case before them. What the court smartly did was to say that the Aggah Voice of Freedom does not have the locus to bring this action against the oil company on behalf of the community. Disregarding also a body of evidence that shows that over 2,000 residents of the community signed an authorization document asking the Aggah Voice of Freedom and her leadership to bring this action on their behalf with support from the law firm of Chima Williams and Associates and advocates for community alternatives.
Absolutely.
Okay? So the court did not deny the existence of the problem, but smartly dodged, looking at the major and critical issues that arose.
Barrister Williams, and you've also confirmed that that's the reason you are seeking to appeal, this particular judgment, and the fact that it is understood that communities in the Niger Delta, rivers, they are facing environmental challenges due to the activities of these oil giants. But the community now looking to file this appeal, arguing that the remediation should be judged by effectiveness rather than by whether certain engineering works were merely completed on paper. So as this matter actually moves to the court, the higher court, what are the key legal questions we are likely to determine that will likely determine the outcome, which I would like you to highlight here? Would it be the interpretation of the settlement agreement, the issue of legal standing, or the scientific evidence linking the flooding to oil infrastructure? That is on one side. On the other side is that communities are also closely watching this. The communities in Niger Delta, for instance, they are watching these environmental disputes. So do you think the outcome of this appeal could establish an important procedure for future claims involving flooding, pollution, and ecological damage allegedly linked to extractive industries?
All right, thank you very much. Now, one of the critical successes of this case, irrespective of the fact that, our other claims were denied, is that this case has established jurisdiction for an Italian court to hear a complaint from a Nigerian victim over the Italian oil company's operations in Nigeria. Two, this judgment has also established the right of Nigerians to bring an action against a divested oil company, whose parent company is still in existence, in a complaint against legacy environmental problem that existed and had been complained about before the divestment took place. And of course, this case, if the Court of Appeal in Milan overturns it, which we believe that they are going to do, because the Court of First Instance is empaneled by a single judge whose decision is final. But on appeal is empaneled by a minimum of 3 judges, the justices, who may look at the issues from various angles. And we believe that there is no court. I mean, it is an obscene scenario for a court to order the doing of an impossibility. And in this instant case, the lower court in Milan, awarding a cost of close to 200,000 euros against a community that is complaining of their livelihood source being destroyed, of health challenges being created, of their environment being destroyed. I mean, and their economic powers being depleted. Such victims, you are ordering them to pay such humongous amount to the victor, to the oppressors, the oppressed being asked to service the oppressor. I mean, it's an absurdity, and I do not think that the Court of Appeal in Milan will uphold that. And if that decision is overturned, if the decision of the lower court is overturned, it will do one thing. It will also, because as lawyers, as environmental lawyers, our cases are not just to bring about, restitution to the communities that their environments have been despoiled, but also to use the legal process and rule of law to bring about peace building in our communities. Because if this case is overturned at the Court of Appeal, it will embolden Niger Delta and other Nigerian communities who are negatively impacted by the destructive activities of multinationals to seek for legal redress rather than seeking for self-help.
Yeah.
But if this judgment is upheld at the Court of Appeal, I can dare tell you that nobody will explain what might likely happen, between the Aggah people and the Oandos and Enis of this world.
But just for you, quickly, because of our time, what do you think the outcome is going to be because of our time?
Yes, if we are not, profoundly believing that the Court of Appeal will upturn the judgment, we will not take up the appeal.
Okay.
Because it's very expensive, it is costly, it is time-consuming, and it is very risky.
Okay.
To take up this type of case against such a big company in their own country. So we have absolute faith in the Court of Appeal that justice will be served.
And we hope so. We hope that justice is truly served at the end of the day. It's a very beautiful place to leave the conversation. Thank you so much, Barrister Williams. Thank you for joining us this morning. Do have a beautiful weekend. Thank you.
Thank you very much.
Thank you. All right.